They laughed at the very idea that a 19-year-old who had never set foot in a law school could walk into a federal courtroom and stand between his mother and a 20-year prison sentence. The judge sighed, like a man watching a child try to lift a boulder. The jury exchanged glances that said everything without saying a word, and the prosecutor, the woman who had built a career on turning courtrooms into her personal hunting ground, she didn't even bother to hide her contempt. She wore it like a badge. She thought it was over before it started. She was wrong in a way that would cost her everything. This is the story of Marcus James, a 19-year-old from the south side of Chicago with no degree, no bar card, and no connections, who walked into the most hostile legal environment imaginable and dismantled a corrupt prosecutor's entire career using nothing but the law she thought she owned. This is what happens when a system built to intimidate meets someone it forgot to scare. Let's start at the beginning, because the beginning matters. You have to understand what Marcus was walking into before you can fully appreciate what he walked out with. His mother, Denise James, was a woman who had spent the last 2 decades doing everything right. She worked rotating shifts at a city-operated housing authority office in Chicago's South Shore neighborhood, data entry, disbursement, processing, fund allocation paperwork. Invisible, essential, underpaid work. She knew the filing systems better than anyone in the building. She was the person her supervisors called when something didn't balance. She had never missed a rent payment, never bounced a check, and owned exactly one thing of value in this world, a small 2-bedroom row house she had inherited from her own mother, a place she planned to leave to Marcus someday. Then one morning, federal agents knocked on her door at 6 a.m., and that morning ended everything she had built. The charge was devastating: conspiracy to commit wire fraud and the deliberate misappropriation of nearly $250,000 from a federally allocated community revitalization fund. The kind of charge that comes with headlines. The kind of charge that gets you fired the same day you're arrested, that freezes your bank accounts before you've even had a chance to call a lawyer, that turns your neighbors into strangers overnight. Here's what the charge did not reflect. Denise James had nothing to do with the theft. What had actually happened, what would eventually come out, was that a sitting city alderman had been quietly draining that fund for 3 years, routing money through a web of shell invoices and falsified digital authorizations. When auditors started asking questions, he needed a scapegoat fast. Denise was the perfect candidate. She had access to the system. Her employee credentials had been used, or appeared to have been used, to authorize several of the transfers. She worked quietly, didn't make waves, and couldn't afford a private attorney. She was in the coldest possible calculus, expendable. The city assigned her a public defender, a decent man, genuinely overwhelmed, carrying a caseload that would have crushed 3 people. He sat across from Denise and told her honestly, "The paper trail looks bad, the prosecution is aggressive, and if she fought this and lost, she was looking at the maximum, 22 years. But if she took the plea, she'd be out in 8 with good behavior." He wasn't trying to hurt her. He just didn't have the bandwidth to fight it. Marcus refused, flatly, completely, without hesitation. He was 19. He had been on a full academic scholarship at the University of Illinois studying computational mathematics before his mother's arrest, froze their accounts, and collapsed his ability to pay for housing and books. He had left school, not because he failed, but because the system had surgically removed his ability to continue. He came home, found his mother aged a decade in 3 months, and made a decision that most people would have called insane. He was going to represent her himself. Under a narrow, rarely invoked provision buried in the Illinois Constitution, a clause that predated modern bar licensing requirements, a blood relative could petition to serve as a legal advocate for a defendant in cases where no adequate counsel had been secured. Marcus filed the petition with precision. He cited the statute correctly. He attached documentation of the public defender's caseload as evidence of resource inadequacy. Judge Raymond Ellison, the presiding judge on the case, reviewed it, questioned it, almost denied it, and then, with a reluctance he made no effort to hide, granted it. That was the first battle. Marcus won it before anyone was paying attention. The prosecutor assigned to the case was a woman named Victoria Holt. If you have been in Chicago legal circles for any length of time, you know that name. Victoria Holt had been prosecuting cases for the city for 15 years. She had a conviction rate that law professors cited in academic papers. She had a reputation for walking into courtrooms the way generals walk onto battlefields, with total situational control, zero tolerance for improvisation from opposing counsel, and a strategic ruthlessness that had broken more than a few experienced defense attorneys. She had been profiled in 2 legal journals. She had a waiting list of junior prosecutors who wanted a second chair under her just to learn her approach. When she saw the name on the defense filing, Marcus James, age 19, non-attorney advocate, she reportedly laughed, genuinely laughed. And then she went back to preparing her case with the same intensity she always brought, because winning wasn't enough for Victoria Holt. The margin of victory mattered. On the first day of trial, she set the tone immediately. When Marcus stood to address the court during voir dire, she objected to the framing of his first question before he had finished the sentence. When he attempted to introduce a procedural motion regarding the chain of custody for the prosecution's digital evidence, she cited 3 separate case precedents in under 90 seconds. All of them accurate, all of them devastating, and sat down with the expression of someone who had just swatted a fly. Judge Ellison sustained her objections more often than not. He wasn't corrupt, he was careful. And careful judges faced with a 19-year-old non-lawyer on one side and a 15-year veteran on the other tend to protect the institution by protecting the professional. Every time Marcus stumbled over a procedural nuance, the judge corrected him from the bench with the barely concealed impatience of a professor who has explained the same concept 7 times. The jury watched. Some of them clearly sympathized with Marcus. Some of them just felt uncomfortable. None of them, in those first few days, looked like they believed him. The prosecution's centerpiece evidence was a series of digital authorization logs, what the city's forensic accountant called an unambiguous digital signature trail connecting Denise James's employee credentials to 11 separate fraudulent wire transfers over 14 months. It was clean, tightly packaged evidence, the kind that makes jurors nod slowly and stop looking at the defendant. Marcus had subpoenaed everything he could get his hands on: server maintenance records, IT communications, network diagnostic reports, the full discovery package. Victoria Holt had complied with discovery. Technically, she had provided over 6,000 pages of documentation. It was a deliberate strategy as old as litigation itself. When you can't hide the needle, bury it in a haystack and hope the other side doesn't have time to look. She had vastly underestimated what Marcus did with time. When Marcus tried to cross-examine the forensic accountant and challenge the digital logs, Holt was on her feet before he finished laying the foundation. She challenged his qualifications to interpret metadata. She challenged his standing to introduce technical analysis without expert credentials. She challenged the admissibility of the server logs he wanted to reference. The judge sustained her on all 3 points. The motion to suppress the digital evidence was denied. From the gallery, it looked like a rout, a professional surgical strike against an unprepared opponent. Marcus sat down. He looked at his mother. Denise James reached over and put her hand on his arm, and in that quiet moment, the moment where most people would begin to quietly accept defeat, something in Marcus James went completely still. Not defeated still. Diamond still. That night, at 11 p.m., Marcus was in the basement reading room of the Harold Washington Library on State Street, the only place that had given him consistent free access to legal databases for the past 7 months. He spread the discovery documents across 3 tables, 6,042 pages. He had read all of them before. He was going to read them again. At 2:17 in the morning he found it. Not the email, not yet. What he found first was a procedural anomaly in the asset forfeiture filing. Victoria Holt had moved to seize Denise James's bank accounts and home on the same day as the arrest. Before arraignment, before any finding of guilt, using a municipal civil forfeiture ordinance that allowed the city to claim assets connected to an ongoing fraud investigation. It was aggressive, but not technically unusual for a prosecutor of Holt's style. What was unusual, what was, in fact, a clear statutory violation, was which ordinance she had used. Marcus had memorized the city's civil forfeiture code structure weeks earlier, not because he thought he would need it, but because his mind didn't work in targeted searches. It worked in comprehensive maps. And the map he had built told him something important. The ordinance Holt had cited to justify the seizure applied to cases where the fraud involved federal grant funds, which this case did. And that same ordinance required mandatory review by a federal magistrate within 48 hours of the seizure order. Holt had bypassed the federal magistrate. She had routed the approval through a local municipal judge. A judge who, Marcus discovered through public court records, had co-chaired a fundraising committee with the alderman at the center of this entire scheme 18 months earlier. That was the first structural collapse point. The seizure of Denise James's assets was procedurally defective at the root. Then Marcus found the email. It was on page 4108 of the discovery package. An internal communication between the city's lead IT systems analyst, a man named Gerald Okafor, and Victoria Holt's official prosecutorial email address, sent 6 weeks before the trial began. The subject line read, "Audit Results, Terminal 4F." The body of the email was 4 paragraphs long. Marcus read it twice. Then he sat very still for a long time. Okafor's email told Holt clearly and in plain language that a forensic audit of the 4th floor terminal, the machine from which the fraudulent transfers had been allegedly initiated, had revealed the presence of a remote access Trojan, a specific category of malware that allows an external actor to commandeer a machine and operate it remotely while masking the origin point. The audit had further traced the actual originating IP address through a chain of offshore proxy servers that had no connection to Denise James. Okafor had concluded explicitly that Denise James's credentials had been stolen and used remotely without her knowledge or participation. He had attached a full diagnostic report. Victoria Holt had received this email. She had read it, and she had buried it in 6,000 pages of discovery on page 4108 without ever flagging it, disclosing it as exculpatory, or informing the defense of its existence in any meaningful way. Under Brady v. Maryland, one of the most foundational rulings in American criminal procedure, a prosecutor is constitutionally required to disclose any evidence that is favorable to the defendant. Not optionally, constitutionally. The deliberate suppression of exculpatory evidence is not a procedural error, it is prosecutorial misconduct, it is a felony. Victoria Holt, the woman with the 15-year record, and the law journal profiles, and the reputation for absolute institutional control, had committed a crime. She had done it deliberately. And she had hidden the proof on page 4108, betting that a 19-year-old with no legal training and no support staff would never get there. She had bet wrong. Marcus didn't shout. He didn't call anyone. He sat in the basement of the Harold Washington Library at 3 in the morning with the quiet, focused energy of someone who has just seen exactly how the next 4 hours of their life need to be used. He began to write. Not notes, not summaries. A trap. When court resumed the next morning, the gallery was fuller than it had been on any previous day. Word moves fast through a courthouse. People had heard the story, the kid lawyer, the legendary prosecutor, the seemingly inevitable conclusion. Several law students from DePaul had come to watch what they expected to be the final chapter. A few reporters sat in the back row with that particular kind of alert stillness that journalists get when they think something might actually happen. Denise James sat at the defense table, looking like a woman who had already said her goodbyes. She had barely slept. When Marcus sat down beside her and opened his folder, she leaned close and whispered, "Whatever happens today, I need you to know." "Mom," Marcus said quietly, not looking up from his papers. "Watch what happens next." Judge Ellison called the court to order. He looked at the defense table with the measured expression of a man prepared to wrap something up. "Mr. James, the prosecution has rested its case. Does the defense wish to present any final evidence or call any final witnesses before we proceed to closing arguments?" Marcus stood. He straightened his jacket, the same borrowed jacket from the first day, still slightly too large in the shoulders. He did not reach for his notes. "Your Honor," he said, "the defense has one final witness." Holt didn't look up from her legal pad. "I'd remind the court," she said, her voice carrying its habitual smooth authority, that any witness the defense plans to call should have been on their disclosed list if Mr. James is about to attempt another procedural improvisation. The defense calls Victoria Holt to the stand. The room went quiet in a specific way, the way rooms go quiet when something genuinely unexpected has happened and no one is sure yet what it means. Victoria Holt's pen stopped moving. She looked up. Judge Ellison leaned forward. "Mr. James, you're asking to call the prosecuting attorney as a witness. That is an extraordinarily unusual request and is generally prohibited under professional conduct rules. Can you give the court your legal basis for this?" Marcus reached into his folder and removed a single page. Your Honor, I am invoking 725 ILCS 51115-14, which permits opposing counsel to be called as a witness when the attorney possesses non-privileged factual information that is material to a claim of prosecutorial misconduct, where that information cannot be obtained through any other available witness, and where the claim cannot be properly adjudicated without direct testimony from the attorney in question. Holt was already on her feet. Objection, this is theatre. There is no misconduct. This young man is desperate, and he is turning this courtroom into a performance to distract from a case he cannot win. I move that he be held in contempt immediately, and that we proceed to closing arguments. Marcus turned to face her calmly. Your Honor, if the court will permit me to make an offer of proof, I can establish within the next 5 minutes the foundation for calling Miss Holt. And I want the record to reflect that. If the court denies this request, the defense will move immediately for a mistrial with prejudice on the grounds that the prosecution has engaged in the deliberate suppression of material exculpatory evidence in direct violation of Brady v. Maryland, 373 U.S. 83. The phrase hung in the air like smoke, Brady violation. Every attorney in that room knew what it meant. The jury didn't know the case name, but they could read the room. They could see that the prosecutor, who had spent 4 days looking at this teenager the way a chess grandmaster looks at a beginner, was now gripping the edge of her table. Judge Ellison looked at Holt carefully. His voice was deliberate. Miss Holt, before we go any further, I want to ask you directly for the record. Is there any exculpatory evidence in this matter that has not been disclosed to the defense? Absolutely none, Your Honor. Her voice was steady, professionally steady, the voice of someone who had controlled difficult rooms for 15 years. The defense has received complete discovery. Everything we have, they have. Let the record reflect, Marcus said immediately, his own voice now carrying a clarity that had not been in it 4 days ago, that the prosecuting attorney has stated on the record in open court that no exculpatory evidence exists that has not been provided to the defense. He turned and walked to the center of the room. Your Honor, I'd like to submit Defense Exhibit 61. He handed a folder to the bailiff, who carried copies to the judge and to Victoria Holt. The moment Holt opened the folder, something changed in her face. It was subtle. The kind of change you would miss if you weren't watching for it. But Marcus was watching for it. He had been watching for it. Exhibit 61 is an email communication sent from Gerald Okafor, Senior Systems Analyst for the City of Chicago Department of Information Technology, to the official prosecutorial email address of Miss Victoria Holt on the 14th of September, 6 weeks before this trial began. The email presents the findings of a forensic audit of Terminal 4F in the municipal building. The terminal identified in the prosecution's own evidence as the point of origin for the fraudulent transfers. Marcus walked toward the jury box, not theatrically, just directly, the way someone walks when they are not performing and are simply telling the truth. That audit found a remote access Trojan, malware, installed on Terminal 4F. It found that the fraudulent transfers were not originated from within that terminal by a physical user, but were executed remotely by an external actor who had compromised the machine. It found that the employee credentials used to authenticate those transfers, my mother's credentials, were stolen, spoofed, used without her knowledge from an offshore server chain that Gerald Okafor traced and documented in full, and his conclusion written plainly in that email is that Denise James did not commit this crime. The courtroom was so quiet you could hear the ventilation system. Ms. Holt received that email. She received the diagnostic report. She knew, 6 weeks before this trial started, that her star forensic witness was testifying to a digital record that her own IT department had already proven was fabricated. She buried it on page 4108 of a 6,000-page discovery package and told no one. Holt's chair scraped back. That report was inconclusive. We had significant methodological concerns about Miss Holt. Judge Ellison's voice came down like a door closing. Stop talking. The judge was reading the email. He read it twice. He read the attached diagnostic summary. When he looked up, the expression on his face was one Marcus had not seen from him in 4 days. It was not impatience. It was not pity. It was fury. Is this document authentic? The judge asked. Holt said nothing for a long moment. Your Honor, the report was preliminary. Is the email authentic? Another pause. Yes. And you received it 6 weeks ago? Yes. And you did not disclose it? Silence. Judge Ellison set the paper down on his bench with a precision that was somehow more frightening than if he had thrown it. This is not a close call. This is not a grey area. This is one of the most explicit Brady violations I have seen in 31 years on this bench. He looked at Holt with an expression that was almost sorrowful in its severity. You have deliberately withheld the single most material piece of evidence in this case, evidence that directly exonerates the defendant, in order to secure a conviction you knew you were not entitled to. Marcus was not finished. Your Honor, there is one additional matter. The Brady violation does not exist in isolation. It is the foundation of a broader constitutional problem. He pulled out the second page of his notes, the one he had written at 2:30 in the morning about the civil forfeiture. The asset forfeiture executed against my mother, the seizure of her bank accounts and her home, was filed under Municipal Ordinance 409, which governs forfeiture in cases involving federal grant funds. That ordinance requires mandatory review by a federal magistrate within 48 hours of execution. That review did not occur. Miss Holt routed the approval through a local judge, one whose documented associations with the alderman at the center of this investigation raised serious questions about the independence of that approval. He paused. The Supreme Court's ruling in Timms v. Indiana, decided unanimously in 2019, incorporated the Eighth Amendment's prohibition on excessive fines against state and local governments through the 14th Amendment. The seizure of my mother's home, her only asset, the home she inherited from her own mother, for a crime that the prosecution's own internal evidence showed she did not commit, is not merely excessive. It is the deprivation of a property right under color of law. That is a federal civil rights violation under 18 U.S.C. Section 242. Marcus turned to face Judge Ellison directly. I am asking this court for the immediate and unconditional dismissal of all charges against Denise James with prejudice. I am asking for an emergency injunction restoring all seized assets to my mother immediately. And I am asking this court to find, on the record, that the application of Municipal Ordinance 409 in this proceeding was constitutionally defective, establishing precedent that will prevent this same mechanism from being used against other families who do not have someone willing to read 6,000 pages. The courtroom did not explode. It exhaled. Judge Ellison sat back. He removed his glasses. He pressed 2 fingers to the bridge of his nose and sat in silence for what felt like a very long time, but was probably 45 seconds. When he spoke, his voice had dropped to something quieter and more serious than anything Marcus had heard from him all week. I have been on this bench for 31 years. I have presided over complex fraud cases, civil rights suits, cases that went to the appellate court and came back twice. I have seen brilliant attorneys, and I have seen brilliant arguments, and I want to be honest with this court. When this young man filed his petition to represent his mother, I was skeptical. I want that skepticism noted in the record, because what I'm about to say is the more important part. He looked at Marcus. I was wrong to be skeptical, and I will not make the mistake of underestimating what I'm looking at again. He picked up the gavel. All charges against Denise James are dismissed, with prejudice. The prosecution is barred from ever refiling. The court grants the defense motion for an emergency injunction restoring all assets to Mrs. James, effective immediately. The court further finds, for the record, that the application of Municipal Ordinance 409 in this proceeding was constitutionally infirm, and that this finding shall be entered into the record as binding precedent establishing the requirement of federal magistrate review in all future applications of said ordinance. He turned to Victoria Holt. As for you, you are stripped of standing in this courtroom as of this moment. I am referring this matter to the Illinois State Bar Association for disbarment proceedings. I am forwarding a full transcript of today's proceedings to the United States Department of Justice with a recommendation for investigation under federal civil rights statutes. Bailiff. 2 officers approached the prosecution table. Victoria Holt stood for a moment without moving. Her case files were still spread neatly in front of her. Her legal pad was still open to a page of notes she would never finish. She looked at Marcus once, just once, and there was nothing performative in the look. Whatever armor she had worn for 15 years was simply gone. She was escorted out of the courtroom. She had dominated for over a decade, and she did not look back. Denise James did not say anything for a long time after the gavel fell. She sat at the defense table with her hands folded in front of her, and tears ran down her face silently, while the room around her dissolved into noise and motion, and the frantic energy of reporters reaching for phones. Then she turned to her son, and she pressed her forehead against his shoulder, the way a person does when they have been carrying something unbearable for a very long time, and have just been told they can put it down. Marcus wrapped his arms around her and held on. "We're going home, Mom. We're going home." The aftermath moved fast. The way things move fast when corruption has been holding a structure in place, and the structure suddenly isn't there anymore. Gerald Okafor, the IT analyst, whose email had been buried, came forward publicly within days. He had sent the email and wondered why no one ever acted on it. Now he knew. The DOJ investigation that followed Holt's referral pulled the thread that unraveled the alderman's entire scheme. 3 years of diverted federal funds, a network of falsified vendor contracts, and a pattern of using low-level city employees as procedural cover when audits got too close. The alderman was indicted on 11 federal counts. He did not take a plea. Victoria Holt, facing federal civil rights charges and a disbarment proceeding that her own colleagues refused to contest, eventually cooperated with investigators. She was sentenced to 4 years. She served 3. Municipal Ordinance 409 was overhauled by the City Council within 60 days, under significant public pressure, citing what the legal community had already begun calling the James Standard, the requirement that civil asset forfeiture in federally connected cases receive independent magistrate review before execution. Advocates estimated that the procedural change would protect several hundred families per year in Chicago alone from pre-conviction asset seizures. As for Marcus James, the morning after the verdict, his phone had 17 missed calls. One of them was from the admissions office at Yale Law School. One was from Northwestern. One was from Howard. He called his grandmother first. He enrolled at Howard University School of Law that fall on a full merit scholarship, with the undergraduate requirement waived on the basis of documented exceptional legal performance. He was 19 years old. There is something important to understand about what Marcus James actually did in that courtroom. He did not win because he was clever. He did not win because he had a dramatic moment and the truth happened to be on his side. He won because he outworked everyone, because he read 6,000 pages while they assumed he wouldn't, because he had mapped a legal architecture that his opponent had stopped looking at carefully years ago in the comfortable certainty that no one on the other side of her cases would ever look that carefully either. The systems that are designed to overwhelm the enormous discovery dumps, the procedural complexity, the credentialing requirements, they are powerful tools. They work most of the time. They work because most people, when confronted with 6,000 pages in 5 days, do not read to page 4,108. Marcus did. And that is the lesson. Not that brilliance beats corruption, though. In this case, it did not, that the truth always wins, because it often doesn't. The lesson is that the law, even when it is wielded against you, contains within it the mechanisms of accountability. It contains Brady, it contains Timms, it contains the 14th Amendment and the 8th Amendment, and 100 years of case law built by people who understood that a legal system is only legitimate if it can be turned by anyone, not just by those with credentials, against those who abuse it. Victoria Holt spent 15 years believing the law was a club that belonged to the professionals. She was right that it usually works that way. She was catastrophically wrong that it could only work that way. A 19-year-old in a borrowed jacket showed her the difference. He showed a packed courtroom. He showed the reporters in the back row. And now, in whatever form this story reaches you, he's showing you too. The truth doesn't always come with cameras. But when it does, when someone with nothing but intelligence, preparation and love walks into a room and refuses to accept the verdict that the room has already written, that is something worth paying attention to. Marcus James did not walk into courtroom 302 to become a symbol. He walked in to bring his mother home. He did both. If this story reminded you that justice is still possible when someone refuses to stop fighting, share it with someone who needs to hear that today. And if you want more stories about ordinary people who changed extraordinary circumstances, you know what to do.